Heiko, why does your icon suddenly look different? Picture of you that I'm seeing in front of me is not the Heiko that I'm used to.
No, it is. I think it's the student photo.
Okay. Okay, and then I need to share my, okay. Before I share my screen, just quickly, test one. I've marked all the students that wrote in Windhoek. I've only got the last of the students that wrote in the regions today, so I'll be marking them. You'll have the marks all released before the end of the week. Just bear with me. The results that I've marked so far, in general, I'm satisfied. It seems you are all on the right track. It's looking, I'm honestly, I'm very proud of my part-time / distance students, because I'm also marking a very, very large quantity of full-time students. And the poor school leavers, the full-time students, are doing very, very, very badly. It's absolutely shocking. Your results were not shocking at all. Some really good ones, some not so good ones. In general, I'm satisfied. Your test 2 is an online test. And in general, the online, students generally do better in the online tests. So even if for this test, when you get the results, if you're slightly disappointed, don't give up. It's not the end of the world. There is still half a semester left for you to pick up. So I'm very confident that we will have a good average, a good pass rate in this class. For the students, and I'm talking now to the students that I regularly see in class, I marked some tests of names that I did not recognize at all, that I have never seen, that have obviously never attended a class. And the results reflected this. So do try to attend the classes if you can. If you can't, at least listen to the recordings. Preferably do both, attend the class and listen to the recording afterwards as well, to just reinforce everything. Not easy, but it is also not impossible. Okay, I'm sharing a screen. The moment it's just a blank page. There's nothing on it. Notes, previous notes, I tidied up and have already shared with you on WhatsApp. I'm starting a new page with notes now. So we're moving on. What we're doing this week is Unit 10. What we've done is we looked at the principles of purchase and sale. Oh, sorry, I'm ahead of myself now. We started off looking at the general principles of the law of contract. When is a contract valid? The requirements for a valid contract, some terminology, some terms of a contract, breach of contract, remedies for breach, how does a contract come to an end? And then we started moving on looking at specific contracts. What I explained to you is you get different types of contracts, different categories of contracts. And each of them have their own natural legal consequences. Sorry, forgive me if I cough. I've got a bit of a bad chest. So you get different categories, different types of contracts, and each of them have their own natural legal consequences. Obligations, rights, and duties that flow from a particular contract purely because it is this type of contract. We saw that when we looked at contracts of purchase and sale. That was the first type of special contract that we look at, purchase and sale. And we saw there are the seller has got certain legal duties. The duty to keep the thing in safe custody, the duty to deliver, etc., etc., which they have purely because this is a contract of purchase and sale. Now, today, or for this week, we are moving on and looking at lease agreements. These natural legal consequences that attach to a contract of purchase and sale do not necessarily attach to a lease agreement. Lease agreements have their own natural legal consequences that will apply unless they have been specifically excluded by the parties. So first of all, before we start talking about lease agreements, we need to know what is a lease agreement. So a lease agreement is an agreement, a contract between two parties. Remember, if I say two parties, it can be more than two. I'm just using two to make it easier to understand. So it's a contract between two parties in terms of which the one party, which is known as the lessor, agrees to give the use and enjoyment of a property to the other party, which is known as the lessee. Oops. In return or in exchange, the payment of rent. So that is a working definition of a lease agreement, a contract between two parties in terms of which one party agrees to give the use and enjoyment of a property to the other party in return for the payment of rent. Now, in order for a contract to be classified as a lease agreement, as was the case with purchase and sale, we learned that there were certain requirements that had to be met for a contract to be classified as purchase and sale. Similarly, in order for a contract to be classified as a lease agreement, there are certain requirements. First one, obviously, the contract must be valid. This is still a contract like any other contract. It needs to meet the requirements, those 5 requirements for a valid contract. Second requirement is that the lessor gives the use and enjoyment of the property. Important thing here is that this use and enjoyment is temporary. And then there must be the rental. The amount of rental must be agreed upon. Those are your requirements for a valid lease agreement. Once again, you can be prepared for structured application. My typical question, each of the following examples. Valid lease agreement. Motivate your answers. Typical, you had a similar question in test one. Remember, if I'm asking you to motivate your answers, a motivation to the legal principle. Do not just repeat the facts. Once I've published the results for test one, I will, even if I have to do it on a Saturday morning and just record it, I will spend a short session going through the test with you. I will also in due course share the memorandum. I want to finish marking first, but I will also have a short session to discuss the test with you, to point out common mistakes. One common mistake, if I can mention that now, is with question 3.1. A large number of students told me that, quite correctly so, that the contract was not valid, but as a motivation they gave because he had been drinking or because he was drunk. That is not a proper motivation. That is a repetition of the facts. I didn't give you 0 for that. I gave you half a mark. So if you said it's void because he was drunk, you got 1.5 out of 2, but not 2 out of 2. The motivation there was no consensus or there was no contractual capacity. Remember to always refer to the legal principle. But moving on then, let's look at, in order to apply these requirements, you need to have a little bit more information about them. So the first one is the use and enjoyment of the property. First of all, just quickly, the textbooks and the notes refer to the use and enjoyment of the property. Use and enjoyment is a legal phrase. It's legalese. Last year, I had a query from a student when we were doing this particular part of the work, when I was talking about use and enjoyment. They asked, but so if you don't like it, you're happy to stay there, you're not enjoying it, does that mean it's not a valid lease agreement? No, not at all. Please make sure you understand this. Enjoyment here doesn't mean taking pleasure in. It's not a requirement that it must be pleasurable. It must be a good experience. So if it's bad, then it's not a lease agreement. Use and enjoyment is just a legal phrase. You can actually just say the use of the property. You can delete the and enjoyment at all. It doesn't actually add to the thing. So it's the use of a particular property, which can be movable or immovable. Movable property, things that you can pick up, that you can move. Immovable property, land, houses, a farm, etc., etc. There are some small differences with regard to lease agreements for movable and immovable property, but the basic principles remain the same, regardless of whether this is movable or immovable. So basically, anything can be let, anything can form the subject of a lease agreement, but important, that the parties must be in complete agreement about the subject matter of the lease. You don't always have to let or hire the entire property. The thing can only be partially let, or you can rent only the part of the thing. Examples of this is, you see this quite often, schools do this. They rent out advertising space on the walls of their buildings. So whoever is going to rent that space and put up a billboard and advertisement is only renting that particular, they're not even renting the whole wall. They are just renting that space. But this is a lease agreement. They are being allowed to use that space in order to put up an advertisement. Renting only a part of the thing, you don't have to rent my whole house. You can rent only a room in the house. Parties must be in complete agreement about the subject matter of the lease. It must be identifiable. And this is important, that it must be the actual space, even if it is just a part of a property, must be specified and specified. To illustrate this, for example, I rent a parking space at Nust, undercover parking space. Every month, a certain amount is deducted from my salary, from my payslip, for the use of a particular parking space on campus, which has a number. It is that parking space is my parking space, and I'm the only person that is allowed to park there. Somebody parks there that's not allowed to park there, I can call security and I can get them clamped. So I rent a specific parking space on the NUST upper campus. If, however, there was a huge parking area and I paid a monthly amount to be able to park there, but I could park anywhere. So if somebody has a property, they've put up some shade nets and people pay them for the right to park there during the day. But it's not a specified parking space. They can park anywhere on that property where there's an opening. That is not a lease agreement. It's still a valid contract. You can quite validly do that, but it is not a lease agreement. Why is it not a lease agreement? Because the thing that is being let, that is being rented out, is not specified. Do you understand that? Everybody with me? If you're renting immovable property, structures will form part of the lease. So if you are renting a farm and there's a house built on that farm, that house will automatically form part of the lease agreement. The furniture in the house, not. Movables must be specified. So if you're renting a farm and there's a house on the farm, the house will automatically form part of the lease agreement. But if you want the furniture, the use of the furniture that's in the house, this has to be expressly specified in the agreement that the furniture is included. The next requirement is that the use and enjoyment must be temporary. Contract of sale and a lease agreement. I've asked this before, I can very well ask this again. What is the main difference between a contract of sale and a lease agreement? Who's going to try to tell me this? Who's going to try to answer? What is the difference between the main difference? Remember, if I'm asking for the main difference or the most important difference, I'm looking for one difference, not for 10 other differences. Jane, what do you think?
I think the main difference here is that the lease agreement's use and enjoyment is temporary, and the sale is a transfer of, okay, not ownership per se, but transfer of
Possession,
the
but intention is ownership as well. Yeah. Perfect. Very, very excellent insight there. The main difference, when you buy something, okay, we have learned that ownership is not, doesn't necessarily pass, you have to be the owner, blah, 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 blah. But given all of that, when you buy something, you buy it with the intention that you want to keep it. Whereas if you rent something, is temporary. You will not get to keep it forever. So yes, excellent insight there, Jane. That is exactly what I was for. A lease is temporary. So let me give you, I'm going to ask you a question here to see, test your insight further. I enter into a lease agreement with Haiku that he can rent a room in my house until I die. Will that be a valid lease agreement?
According to me, yes.
Are you saying it will be a lease agreement?
Yes, because you
Yeah.
specified a time.
Yes, it's a valid lease agreement until it changes ownership when the person dies. Then it's no longer a lease agreement. It falls out and become.
Now, Jane, you're going too far now. You're going too far now. But you and Heiko were both absolutely correct. Heiko rents a room in my house until I die. That is a valid lease agreement because I am going to die. And the moment I die, it doesn't change into anything else. The lease agreement terminates. It comes to an end. So he doesn't get the use of that room permanently, forever. It will come to an end. Important reason why I'm using this as an example, it must be temporary. However, the end date
Depends on.
yeah, the
That
end date does not have to be determined. You don't have to specify in a lease agreement that it will end on whatever date. As long as it is determinable. So it can be a specific, when something, for example, when a specified happening, a specified event. So a lease agreement up to the end of my natural lifetime is a lease agreement because you can determine when it will end. It ends when the specified event, in this instance, my death, when it occurs. So temporary doesn't mean it has to be attached to a particular date. It can be for a fixed duration, a month, 2 months, a year, 3 years. Can be a fixed duration, or it can be indefinite. If it's indefinite, it doesn't even have to be coupled to the happening of a specific event. But if it's indefinite, there must be some method of it coming to an end. Some method of it coming to an end, either by way of a specified event or to copy this here just to make my notes clearer. So when a specified event occurs, or if it's not a specified event, it can be terminated by way of either party giving notice. Later in this unit, we'll get to that on Wednesday evening. We will be looking at termination and renewal of lease agreements. So, important takeaway from this is that the use and enjoyment must be temporary. It cannot, the moment it's forever, it is no longer a lease agreement. Questions about this? Everybody comfortable? Okay, and then the third requirement is the payment of rent. As is the case with the purchase price in a contract of purchase and sale, it must be fixed or ascertainable. So you can either fix it as in $1,000 a month, or it can be if you're renting a shop, for example, and you agree that the price, the rental payable will be 10% of the monthly profit. So it's not a determined amount, but it's ascertainable. You can calculate it by way of making a simple calculation. It must be primarily in money. So Jane, your microphone, your sound is nice and loud. That's why I'm using you. Let's say, Jane, that I agree with you that you can come and stay in my house. You've got the use and enjoyment of a room in my house for the rest of the year. And in exchange for staying in my house, you must cook for me every night. Is that a lease agreement?
I'm not sure. So I don't pay rent. I just cook for you. Is that the payment?
I don't want to use the word payment, but
Okay.
But in exchange, instead of giving me money, you are cooking for me every night. Is that a lease agreement? Based on this last thing that I've put up there. Heiko gave a thumbs up, but Heiko didn't look at my notes.
Primarily in money. So there must be a monetary value attached to this agreement.
Jane, I'm going to give Apollonia a chance because she raised her hand. Apollonia, what do you think?
Jane actually just gave it away by saying it must be there must be a monetary value attached to it. So that's what I wanted to say.
It's not about the value attached to it.
Okay, then can I try again?
It must be in money. Not saying, I didn't say, my words on my note says it must be in money. It must primarily, the largest amount must be in money. I didn't say it must be worth something. I said it must be in money. So is her cooking for me? Is that in money? Is she giving me money?
Then it's not.
No.
Then no.
She's not giving me money. It's not a lease agreement.
Okay.
It's still a valid contract. Remember this the whole time. I'm not saying it's now suddenly void or you can't do this or it's illegal or whatever. I'm not saying anything of that. I'm simply saying it's not a lease agreement. Because for it, she needs to pay me money. If she's staying in my house in exchange for doing something that is valuable to me, it's still a legal agreement and we can do that, but it's not classified as lease. For a lease agreement, the largest part must be cash money. If we agree that she pays me $1,000 a month and cooks for me twice a week, that would be a lease agreement because the largest portion is money. Cooking is just something additional. So it doesn't have to be entirely in money. There can be goods or services as well, but the largest portion must be actual cash money. Not meaning you have to pay in notes. You can do a bank transfer, but you know what I mean. Are you with me there? Is everybody with me? There's one exception to this. The exception comes up in the case of the so-called rural lease. A rural lease, that's the legal terminology that we use for farmland. A rural lease can be a combination of a defined quantity or weight of the fruits produced. So if you rent a farm from me, a rural lease, a farm property, it can be in total or partly. So for a rural lease, we can agree that you pay me $5,000 a month plus 5 calves or 10% of the calves born on the farm. Or a rural lease can even be, okay, you lease it because it can be in total a defined quantity. You can rent a farm property from me, and our agreement can state that the rental will be 30% of the mahangu harvested annually. So urban property in towns, primarily, so the largest part must be in money. A rural lease is an exception. Rural lease can be in total or partly a defined quantity of the produce. So a defined quantity of the produce. A lease agreement for a farm stating that instead of paying, you will work for me is a valid contract, but not a lease agreement. You'll rent the farm and you'll give me 50% of the produce is a lease agreement. Is everybody with me?
Yes, ma'am.
Okay. So once we've met those requirements, we have a valid lease agreement. And obviously, as is the case with the contract of purchase and sale, once there is a valid lease agreement, then there are certain duties for both parties, the lessor and the lessee, that flow from this agreement. I'm not going to start with those now. This hasn't been that long a class, but I think I need to leave this with you now so that all of this can sink in and you can become comfortable with what a lease agreement is. The rights and duties are actually short and sweet. We'll go through them quite quickly. So I will leave those to Wednesday. Thank you very much. Thanks for joining. Any last questions? Okay, have a wonderful evening. Don't know if it's raining.
I have a question.
Yes, Apollonia?
I have a quick question. Do these agreements or laws apply to other, let's say, SADC countries as well, or only Namibia?
I am teaching you Namibian law.
Okay.
Most of these principles are fairly universal. So they will, for example, apply with maybe just some few changes in South Africa as well, because our legal systems are still fairly similar. I have very little knowledge of Angolan law, so I'm hesitant to answer you there. But most of these principles are fairly universal, but they will not necessarily apply in every country in the world exactly the way that I am teaching you, because I am teaching you specifically Namibian law.
Okay, ma'am. All right. Good. That's all that I wanted to understand. Thank you.
Okay. Thank you. Have a lovely evening.
Thank you. Likewise. Bye.